said, this is stuff you and I had talked, I said, hey, Mike, what about the old deeds? And we went through all that. That's all gone.
The variance is gone. He did bring up the 1 foot,
Right.
and that was discussed at a board meeting at some time in the past. That was brought up. I don't know what else to add. I entertain any questions.
But I think, again, for me, because there's quite a history here. Back with the deed and no deed, hey, if I can't sell it, then I'll get a 99 unit. All that stuff's gone. But if there's a reason to allow what we're entertaining tonight, and that 1 foot, there's a reason under these circumstances to waive that requirement, I think we're well within our rights to do that as long as it's not a hazard, a public health hazard, or that we are violating some unbelievable law that under these circumstances can't be waived as long as we monitor it. I mean, I think that's important. And if there is no way we can do that after consultation with legal counsel and everybody else, then I think we got a problem. But my understanding is that's not a problem. That as long as we monitor it, that the reasonable health department and our environmental folks say we're okay proceeding under these guidelines. And if that's the case, then I'm ready to make a motion, subject to approval of the county commissioners and the proper mechanical documents being signed by Mr. Kessler W1.
Mr. Holman, do you have a question?
You do have a memorandum of understanding with the Ohio EPA, and it specifically states that this system would be under the NPDES permitting procedure, and you are to adhere to that law. Now, at the last board meeting, right here in your minutes, the board explained that they have to follow the rules that they adopt and agree to enforce. That was an agreement you had with the Ohio EPA for Mr. Urey's orchard, the sewage system up there. So you also have this memorandum of understanding with the Ohio EPA to have control over these discharging systems. And that agreement says that you will follow the state EPA laws on it.
Are these
And
both
it
systems?
says you're
both
50
systems?
feet in the river and everything else.
Well,
Your laws are based right off of their laws.
Ed can handle the Erie question. On the NPDES permit, this system is not eligible for the NPDES system, simply because his system went in at 02. The NPDES permit became effective in 2007, and it clearly states in the permit limitations of coverage. And one of the criteria for limitations of coverage is existing systems, any discharge from existing sewage treatment system is not covered under this permit.
Well,
And we did check with the Ohio EPA.
Yeah.
Let me finish. We checked with the Ohio EPA on this permit because through the course of this whole process, not only have you brought up issues, but Mr. Kessler has come before this board in 09, 04 about various scenarios because he wanted to sell the property, this and that. We dealt with that issue. We're trying to deal with your issues. And in the course of all this matter, we've talked to Ohio EPA. We discussed this specific system, and this system is not eligible under these permit guidelines. Now, if and when that system is altered, then it would be subject to the NPDES permit.
Well, let me ask you a question. It was not cited on the property it was applied for.
We've discussed that.
Now,
Talked about
it's
that.
going to go on a new parcel.
So I think right now we need to.
So it would come under the rules to be redone.
The lines are moving, but the system is not moving.
Nothing's moving.
Your property lines are moving.
That's it.
Yeah, but the sewage system is not moving
moving.
anywhere. Therefore, it's an existing system and it falls back to the
Yeah.
rules that were in place when it was put in.
And we're doing the yearly test.
To make sure there's no public health hazard.
Exactly.
I'm not sure what else.
One of the board members back in 2002, when we had the system approved, said that everything comes out the other end of it, you can drink it.
You go ahead. I don't want these spaces of 6
Come
months in the
on. I was
winter.
gonna invite you over for a drink.
Okay.
Not in
I
the
think
winter
what we
for
need to
6
do
months,
now
I
is,
wouldn't
we'll
drink it.
entertain a motion from the board.
Did you ask to hold off on a motion until you had paperwork?
we can.
Well, I'd like for us to proceed with the approval of the annual operation permit contingent upon.
Yeah, I'll sign the paperwork tomorrow. I just got wind that we're about to sign the paperwork. It's kind of funny, I talked to county commissioners yesterday, and said they needed to print everything out, and they would send it to me,
Okay.
So move that we support and approve the recommendation by staff, and certainly with the contingency upon proper documentation, signature, and recording of the variance, the appropriate documents.
Is there a second?
Second.
All in favor?
Aye.
Motion carries. We,
thank you, gentlemen.
we're at resolution 11-1-2, inspection fee for manufactured homes. This third and final reading.
I have nothing further to add. Unless you have any questions.
Motion.
Roll call vote.
Jennifer Egan? Yes. Phil Berg?
Yes.
Dr. Robbins? Nate Norris?
Yes.
Jim Brown?
Well, now we've had the mockery in action, suppose we ought to leave.
May I say something? It was river video recorded in the courthouse in there the other day at the commissioner's office. It was posted on the internet and it had a lot of hits to it. So anybody that comes in here and has the same situation, they will get the same treatment as Mr. Kessler got as far as if they're illegal, but the system's working fine. You'll say everything's fine.
We have to look case by case, and if it follows the law, yes.
Okay.
Agreement for the facility use of Dresden Volunteer Fire Department.
That's an agreement